Hello and welcome. I'm Russell Osgood. I'm the Dean of the Law School, and I welcome you to our open house. We have faculty, we have alums, we have prospective students, current students, and we have a bunch of people, 65 people online too. So it's a pleasure to welcome you. I want to especially recognize our Board of Advisor members who are here and our Elliott Society members here who helped the law school in many ways. The law school is in a good position right now. We yielded in terms of our admissions indicators, the strongest first year class in our history this past fall. And we hope to do the same thing next fall. We have a diverse student body that comes from all over the world, actually, and from all over the United States. And they are great to work with. I taught 83 of them in con law this fall, and it was fantastic. It was they were strong, they were good students. So um, we also have a new dean who's coming, thank God. On July 1st, and she will be coming to the campus in a short period of time to be introduced to the community. We have, besides our JD students, a large LLM program and a small JSD program. And both are strong programs. When I was a law student, one of the most important parts of the whole experience for me was meeting LLM students because they came from all different countries, and it added a lot to my legal education. And some of them are still my best friends. Our JSD program is a small program, mainly for foreign academics who come here. And we had an excellent year this year in our JSD program. The heart of a good law school is, of course, teaching. Law schools, and I say this proudly, uh, the teaching remains more significant than in other graduate and professional programs, and it's a good thing. And our faculty, not only do they teach and interact with our students, but they're also significant creators of knowledge, and they write and have scholarship, which enriches their teaching, but hopefully also contributes to the world. And we have other faculty, one of whom is on the panel for the tax program that will happen right after these remarks who do clinical courses, and they are courses based on live clients and largely in the St. Louis community area. So Sarah's clinic is a low-income taxpayers clinic. And one of the great things about being in a city like St. Louis, I say this as someone who was dean of another law school in a very rural area, one of the great things about St. Louis is you have lots of people. And so you have lots of clients. So you can run robust clinical programs. And this is our clinic's 50th year. We've been around and we're proud of that. We have a major event. Is it April 12th? April 12th, we have a 50th clinical, and I hope some of you can come to that. We also have some joint programs. This is a thing that has grown in law schools in the last 30 years. We have a significant joint program with the medical school called the Cordell Institute for Medicine and Law. One of the interesting things in legal education and in higher education is that law schools have not been able to successfully develop programs with medical schools for a variety of structural reasons. And we have an excellent one, and it's headed by our faculty member here and a faculty member in the medical school. And They do a lot of things. A lot of it is focused on privacy aspects of medical and legal topics. Another interdisciplinary program we have is the Center for the Empirical Research in the Law. When I say that to friends of mine, even friends who are lawyers, they say, "What is that, Russell?" So empirical research in the law is the following, that for years, law professors, and some of them still continue, myself included, will say, well, this is true, as a kind of statistical statement. Well, it turns out lots of things that we think are intuitively true are not true, and that other things that we don't even think about are true. So the idea of empirical research in the law, and Cornell, and in fact, our chancellor is a leader in the field, is that you look empirically at legal phenomena and try and answer the question of, are our suppositions about it true or untrue? And if they're one or the other, how should we reflect that in the law? And it's a large and burgeoning area of legal study. I want to also say that one of the things that stands out about this law school and this university is we have extremely generous financial aid. And this is a result of the generosity of our donors and our alums who have funded both current scholarships and endowed scholarships. And it allows the law school to yield the very excellent students that we have. And I thank all of them who have done it. I want to also recognize our executive director for advancement, Tony Snyder Finch. Tony is back there. And you will see at the reception, if you stay for the reception, which I hope you will, that there are faculty and deans, other deans in the room. And so I think that's about all I will say. And now we're, after a few minutes, those of you who wish to, we'll stay here and then we'll start the tax developments program. And of those of you who want to go out and go on tours or maybe even have a beer in the courtyard, should feel free to do so. So we'll adjourn for 5 minutes. Thanks. All right. Now, now we're going to start the tax CLE. I'm so old. When I went to law school, there was no CLE, and it's been one of the great developments in the American legal system that you have opportunities to continue to learn after you've gone to work or if you're a faculty member. And so we try and do 3 or 4 a year. Now I'm so horrible at tech that I can't even describe what I'm about to say, but this is a thing you have to like suck it into your and then you have to fill out some questionnaire and in order to qualify for the 1 credit of CLE. And if you have any trouble with it, you should go outside and find Gail Boker and she'll help you to do it. Now we're going to start. So the panelists are to my left, and they may stand up or they may sit down. They're each going to speak for about 10 minutes, and then we'll have questions, and then even questions from the floor. So Sarah Narkowitz, who, as I mentioned earlier, runs our low-income taxpayer clinic, is going to talk first, and she'll introduce herself and talk about what her topic is.
Thank you, Dean Osgood. And as he said, I'm Sarah Narkowitz. I am the Associate Dean for Clinical Education. So while I run the Low-Income Taxpayer Clinic on a day-to-day basis, I run all the clinics on an oversight basis. So we're having our 50th anniversary this year, as he mentioned, and super exciting. So please come celebrate with us in April. But in addition to the 50th anniversary, the Low-Income Taxpayer Clinic is celebrating its 10th anniversary this fall. So that's really something I'm proud of. And what I'm going to talk to you today directly impacts the work we do in that clinic. So what we do in that clinic is we represent low-income taxpayers. And low income can mean a variety of things, but in this context, it means at or below 250% of the federal poverty line. So to give you an idea of what that is, for a household of one, it's about $36,000, and then about $12,000 for each additional household member. And there are people far poorer than that. So the stuff I'm going to talk about today is really impactful on how tax impacts their lives. So as you may know, in August of 2022, President Biden signed the Inflation Reduction Act into law. And that gave the IRS an additional $80 billion in funding, which was super exciting for a host of reasons I'm going to talk about. But the excitement was a little bit short-lived because the following spring, Congress clawed back 20 billion of it. And this month, Congress is talking about clawing it back more quickly. But assuming things stay the same, the IRS has about $60 billion to work with. And that has been incredibly necessary because starting about a decade ago, the IRS funding was essentially decimated. No one likes the IRS. No one wants to pay taxes, so it's never been politically popular. But back in about 2013, if you guys remember, there was a scandal with the tax exempt section of the IRS where applicants applying for 501c3 and 501c4 status that had certain buzzwords in their name were given heightened scrutiny. And one of those buzzwords was Tea Party. And so the Republicans came out against the IRS. Then the Affordable Care Act came into being where the IRS played another impactful part. All in all, 10 years of funding cuts. And just to give you some idea of how this impacted the IRS, in 2010, the IRS had 95,000 full-time employees, and we had a population of 310 million people in this country. Fast forward to 2022, the IRS had 80,000 full-time employees, and we had 334 million residents in this country. And not only did the number of employees drop and the number of people go up, but the things that the IRS was tasked with doing went up a lot. So when we think of the IRS, we tend to think of it as a revenue generating body. You fill out a 1040, you pay your taxes, the IRS processes it. But in addition to being a revenue body, the IRS has been given a really significant role in our federal social safety net. And what that means is the IRS is actually responsible for handling a lot of the benefits that get the lower income amongst us through life, right? So the IRS, starting back in the mid-70s when the Earned Income Tax Credit was created, which is a credit, a refundable credit that helps the working poor. Starting then, they began being responsible for several of these type of issues, including the child tax credit, right? Credit for other dependents. During the pandemic, the IRS was tasked with creating stimulus payments to everyone. And we had an additional child tax credit, an expanded child tax credit that they were tasked with creating. The Earned Income Tax Credit was expanded. So what we have here is the perfect storm. We have a body that's overworked and underfunded. They're doing more than they were originally designed to do. And that's all fine. We don't need to feel sorry for the IRS necessarily. But what happens is that low-income taxpayers are caught in the crosshairs. This has resulted in horrific customer service. And I'm going to talk to you about some of the things. I could give you all these statistics that would make your hair stand on end. But one of the things that was widely publicized during the pandemic was the number of telephone calls answered by the IRS. So in 2021, out of the millions of calls received by the IRS, 11% were answered. And those were answered after significant wait times. I can tell you because I was amongst the 11% of calls answered out of my hundreds of calls made. But by 2022, there was a huge improvement. We got up to 13%. It was abysmal. In addition to not answering the phone, the IRS closed its taxpayer assistance center, so taxpayers no longer had a place to walk in and ask questions. They cut weekend hours. Essentially, you could get nothing done. During the pandemic, when the IRS went away, they didn't have secure laptops, so all their employees were not able to work. So essentially, everything shut down. Why is that significant? Because the IRS is a paper-centric organization. You probably all file your returns electronically, and that's awesome. But as of August 2023, the IRS is still getting about 76 million paper returns a year. And you think, no big deal, you scan those? Nope. The IRS gets the paper return. They require every employee in those campuses to manually type in those returns. So that creates a lot of errors in and of itself. What's happening then is we're having processing delay after processing delay. In addition, because the IRS has no funding, they can't go after high-income taxpayers and they can't go after corporations because these sorts of audits require, a lot of brain power, a lot of work, a lot of time. The IRS just does not have the capacity to do that. That has led to a huge tax gap, which is just the difference between what people actually owe and what they self-report. What does the IRS do in response? They do computer audits because that's all they're capable of doing. But computer audits focus on simple tax returns. And they have primarily focused on refundable credits like the earned income tax credit, the child tax credit, et cetera. So what's happening is that while all audits are going down across the board because there's no manpower, audits for low income taxpayers are going down significantly slower than audits of people with higher incomes. So we are having people get audited for these horrible, for these credits. These credits are legislatively very challenging to begin with. They don't reflect the realities of the American household today. So people that legitimately deserve these credits and need this money to survive are getting caught in the crosshair, either because they've made a simple mistake on their tax return and it's very easy to do, or because the computers have just randomly decided to audit them. So you get audited, what happens? Nothing, right? If you try to respond, you can't call anyone. You have to write a letter because the IRS is very progressive with this technology. You can respond either by mail or by the revolutionary technology of fax. So essentially, no matter how hard they try, without representation, low-income taxpayers are essentially stuck and they're not getting the credits they deserve. So the IRS, as I mentioned, is paper-centric, but they also have abysmal technology. This is a picture of the Austin, Texas campus of the IRS in 2022. This is the lunchroom. There was so much paper to be processed at that campus that nobody could have lunch. So employees that don't have lunch are probably less productive to go back and type in manually all those tax returns. It's a quagmire. In addition, this is the IRS's computer system. So this is something, the IRS has something called your individual master file, which contains all the private information that the IRS has about you and me, your social security number, your earnings, going back decades. It's done in COBOL, which means that the IRS can no longer find anyone that has this programming language. So you worry about identity theft, I do too. So this funding comes into play, thank goodness, right? What will the IRS do and how will it help? So in 2023, the commissioner released these 5 objectives. They want to dramatically improve services to help taxpayers meet their obligations and receive tax incentives. They want to quickly resolve taxpayer issues when they arise. They want to focus expanded enforcement on taxpayers, deliver cutting edge technology, and hire more employees. And I know over time, but I want to say one more thing about who this is impacting. It's not just low income taxpayers, it's specifically Black taxpayers. Black taxpayers are 3 to 5 more times more likely to be audited than other taxpayers. And that is because they're disproportionately likely to claim these types of credits. So lots of problems. Hopefully the money will help.
Thank you. Now Connor Clark.
I'm going to go to the podium.
Okay.
I think Gail instructed me to turn this to.
Right.
Thanks for having me. I'm Connor Clark. I'm an associate professor here. My wife and I just moved here in August of 2023. So thanks for having us. And thank you as well to my federal income taxation students. I see a big cluster of you in the back. I see some of you on the left side as well. Even though I didn't say you have to come, it warms my heart that some of you came nevertheless.
But you did say it would be a good idea.
And there might be exam questions discussed. We'll see. I once heard a joke, or maybe an insult, and maybe actually it was from you, Russell, that all tax professors fantasize about teaching constitutional law. Today I get to live the fantasy by talking mostly about constitutional law. So Moore versus United States, background and potential consequences. The first thing to say about the case is that it's an important one. And to try and quantify this, I just spent some time yesterday searching for evocative headlines from the press. So here's some that I liked. Supreme Court hears case that could make it harder for Congress to tax the rich. All right, seems important. This corporate law case could accidentally overturn US taxes. More of the United States might wreak economic havoc. Sounds important. Supreme Court to consider quadrillion-dollar question in major tax case. So US gross domestic product, I think, is $23 trillion. So this is a case on the order of, what, 50 times US gross domestic product. Seems really important. And finally, Supreme Court hears tax case on income. It may have the biggest fiscal policy effects of any court decision, says experts. So important case, big consequences. What's it about? Well, a good place to start is with the question presented, which is this: whether the 16th Amendment authorizes Congress to tax unrealized sums without apportionment among the states. And what does this mean? Well, there's always a question in law about where to start a story, but this story I'm going to start in 1789. Article 1, Section 8. Congress shall have the power to lay and collect taxes, duties, imposts, and excises, but all duties, imposts, and excises shall be uniform throughout the United States. That's not the only constitutional provision that deals with taxes. I want to introduce you to two more. Article 1, Section 2, representatives and direct taxes shall be apportioned among the several states according to their respective numbers. And Article 1, Section 9 basically says the same thing. No capitation or other direct tax shall be laid unless in proportion to the census. So how do these three provisions add up? Well, in a few ways. We know that indirect taxes must be uniform, and indirect is not a word that appears in the Constitution. It's just the way some scholars have cashed out duties, imposts, and excises. And uniformity just means that the law needs to have the same force or effect everywhere in the United States. We also know that direct taxes must be apportioned. And we can also say a tax is either one or the other. It's not textually obvious from the provisions I showed you, but pretty quickly, starting in a case called Hilton, it seems like the Supreme Court kind of converged on the idea that all taxes were either direct or indirect. They fell under the force of the direct tax clauses, or they were duties, imposts, and excises. We also know that uniformity is pretty easy. I said uniformity could be cashed out as a law just needs to have the same force and effect everywhere. And finally, we can say that apportionment is pretty hard. I was actually talking about this with my federal income taxation students earlier. Conceptually, some taxes you actually just can't apportion. And one case you can think about here is something like progressive taxes. If you apportion taxes like representatives, then the total amount that each state pays must be the same as the percentage of the national population that the state has. So a state like Missouri, which I think has about 2% of the national population, it would need to pay, under an apportioned income tax, 2% of the total tax. But that would mean, paradoxically, that if you wanted to have progressive taxes, poorer states, states poorer than the average, would actually need to have more regressive tax rates on average, because they would need to have higher tax rates to make up for the fact that they were poorer, kind of inverting the whole idea of progressivity. You can't actually apportion some taxes. And for this reason, you really don't want, if you're Congress, your tax to be subject to an apportionment requirement. So the big question then is, what does direct mean? It matters because, as we noted, you don't want apportionment to be, if you're Congress, the requirement that the tax needs to meet. And one person we might ask is Alexander Hamilton. And surely you'd think someone like Hamilton, present at the creation, the OG Secretary of the Treasury, he would know, if no one else did, what direct taxes meant. Well, Hamilton had this to say: "It is a matter of regret that terms so uncertain and vague and so unimportant a point are to be found in the Constitution." Hamilton conceded that the language was not particularly clear. So how did this play out initially? Well, for the first 100 years, direct, as construed by the courts and the Supreme Courts, really didn't mean much. Essentially, it was limited to capitation taxes, head taxes, taxes of the form everyone pay $50, and real estate taxes or property taxes. The reason capitation taxes were considered direct taxes is because the Constitution says that. It says capitation or other direct. So whatever else we might ask about direct taxes, we know capitation is included. The reason certain property taxes were included is because Congress in the 1790s conceded that they needed to be apportioned. Congress actually passed in its early years a few apportioned property taxes. But everything changed in 1895 in the case of Pollock versus Farmers Loan and Trust, which in a convulsive Supreme Court decision held that the 1894 income tax was a direct tax and therefore unconstitutional because not apportioned. Everything changed again in 1913 with the ratification of the 13th Amendment. This was a response to the Pollock decision, though it took 18 years for ratification to take place, which said Congress shall have the power to lay and collect taxes on incomes without apportionment, responding directly to the Pollock case and responding directly to the concern that certain taxes, like a progressive income tax, could not be apportioned. Well, so where does this leave us? We can return to the QP again and more. Whether the 16th Amendment authorizes Congress to tax unrealized sums without apportionment among the states. In other words, does incomes, as included in the text of the 16th Amendment, include unrealized sums? And perhaps restated slightly, if not, is taxing unrealized sums direct and therefore subject to the Constitution's apportionment requirement? A little bit of background about the Moore's particular claim. So you may remember in 2017, Congress sent to Donald Trump for signature and Trump signed the Tax Cuts and Jobs Act. This changed a lot of features of US tax law, but one thing it did was it imposed a one-time tax on the undistributed profits of certain US-owned foreign corporations. Happy to say a little more in Q&A about why the act did this, what the background for it was, but for now, the important part is undistributed, and the Moores claim it's not a tax on incomes if they didn't receive anything. In other words, a tax on undistributed profits doesn't fall under the 16th Amendment's enumerated power to tax incomes. And the Moores had in fact invested in an Indian corporation, a kind of quasi-charitable enterprise, and they thought, set it and forget it. There's some factual disputes about how involved they were with the corporation, but they make the argument before the Supreme Court, we were not involved in the running of the corporation, and crucially, they never received a dividend from the corporation. Well, why does this matter? I just want to conclude by talking about two ways in which the Moore case might affect both the shape of taxes in the US at present and also the shape of taxes to come. The first is that we might want to tax more undistributed sums, to borrow the language from the question presented. And to see this, you can just think about wealth taxes. It goes back to the headlines that I introduced originally. Elizabeth Warren, Bernie Sanders, and others very interested in proposing additional wealth taxes to combat inequality in the United States. And you can also just think about things like mark-to-market taxation. If you were to imagine reforming capital gains taxation in the US, that might look to taxing unrealized gains on certain stocks. The second reason is that we already tax a lot of undistributed sums, and to see that, we can just look to partnerships and S corporations, among other things. This is a big deal. Partnerships and S corporations now earn more than $1 trillion annually, and Peter can probably say more. This is really where the action is in federal law. in federal taxation. And so if more were to cast doubt on some of these taxes, it would have a convulsive effect on present law as it stands. So the bottom line, Moore raises some surprisingly basic questions about Congress's taxing power, questions that you might have thought were answered in 1789, 1913, but perhaps are not. And it has the potential to raise many more. So thank you.
And now Peter Wiedenbeck.
Good afternoon. I want to talk to you briefly about a topic that is generally arcane, and that is federal income tax treatment of retirement savings programs. And in particular, just to have some grounding here, you may be aware that wealth distribution in the United States is very uneven. And much more uneven than income distribution, which has income inequality has been increasing in recent years. Wealth inequality is much more dramatic. So this simple chart is recent Census Bureau data showing at various percentiles of household wealth, right, where the breakpoints are. The lowest 10% of US households by wealth have net worth that is negative. Right, meaning that they have more liabilities than the value of all their property. 90% of the population has some positive net worth, but as you can see, it gets dramatically more on a household basis. The top 90% of the population, right? If you have a net worth, the household net worth of 1.6 million or more, you're in the top 10% of the wealth distribution. Notice the 50%, the median household in terms of wealth in the United States is about $167,000. Above that, you're in the top half of the population distribution by wealth. Below it, you're not. So that gives you a sense of inequality of wealth distribution. Now, you also may be aware just from the news or general reading that most of the wealth for the average household consists of one of two items or both, right? It's either equity in their own home ownership on the one hand, or the amount that they have saved, typically in a retirement savings account. Now, as you can see from this Census Bureau data, overall, the total wealth in the United States in retirement savings accounts is slightly larger than total home equity, but the distribution of the two is very different. Home equity is much more evenly distributed among the population, whereas retirement savings account values, right, are much more heavily weighted in terms of the balance of the accounts in favor of higher income, higher wealth households. But it is true that most individuals, right, who have middle or higher income have some kind of retirement savings account. And what I'd like to talk about today is the importance of those retirement savings accounts and potential impacts on their future in light of recent developments. This is simply an indication of the amount of income that is provided by Social Security retirement benefits as a function of career average earnings. And as you can see in this graph, the bars show career average earnings and how much Social Security benefits are at those earnings levels. And Social Security benefits are based upon basically a 35-year average, right? You can see that as earnings go up, Social Security retirement benefits go up, but they go up more slowly, right? The Social Security system has a progressive or redistributive component built into it, such that low-income earners get a higher proportion of their pre-retirement labor income replaced by Social Security benefits. Whereas as earnings income level from services, right? Labor income increases. Yes, Social Security benefits go up, but they go up more slowly. And the result of that is that the proportion of your pre-retirement, your working years compensation that you can rely upon as being replaced, have a substitute in Social Security old age benefits is highly dependent upon the level of your compensation throughout your career. And notice that if you have extremely low earnings throughout your entire working career, Social Security benefits by themselves replace in excess of 70% of your labor income, your pre-retirement earnings. Whereas as you go up, right, it's for a middle income worker, as you can see, currently less than 50%, about 42% of an individual who spent their career at an average wage job is going to have Social Security benefits replacing it. The consequence of this and the point of this declining replacement rate is that virtually all Americans who are earning more than the minimum wage throughout their career need another source of income once they leave the labor force if they're going to maintain their pre-retirement standard of living. They have to supplement the Social Security benefits with additional savings, right? And for most of us, the additional savings for many of us is through an employer-sponsored qualified retirement plan, right? Pension, profit sharing, stock bonus plan, a 401k plan or the like. Now, that form of saving is encouraged because qualified retirement savings programs get preferential tax treatment. And so what Congress is doing with the special tax treatment of qualified retirement savings plans is encouraging people to save, to supplement Social Security so that they can maintain their standard of living after retirement, right? And most analysts think 70 to 80% of pre-retirement income or earnings is an appropriate target level. And that's going to require substantial additional savings. And for many people, it is provided through some form of qualified retirement savings program. Now, that said, in order to get special tax treatment as a 401k plan, a pension, profit sharing, or stock bonus plan, there are a raft of conditions imposed by the tax code. Most importantly and most fundamentally is a set of rules that are commonly referred to as non-discrimination requirements. In order to get special tax treatment, the employer's program has to broadly cover the workforce. Not everyone, but it has to cover not just the highest paid segment of the workforce. In addition to broad coverage at all compensation levels, qualified plans are required to not discriminate in terms of the amount of contributions or benefits in favor of highly compensated employees. So they have to be effectively even-handed in terms of the proportion of savings that's being provided to the members. Now, that requirement for federal preferential tax treatment for the tax subsidy is important. And it's important because most low and middle-aged income workers do not have the ability to save substantially on their own, right? They don't have a lot of discretionary income beyond what's necessary to meet everyday consumption needs. If they're saving, they may have to save for much higher priority matters like emergency savings, for example, in case of a layoff, or they might be saving for healthcare needs or education or trying to develop a down payment for a home or the like, right? Those reluctant savers, which covers huge swath of the U.S. labor force in terms of low and middle income employees, right, are not in a position to save significantly on their own. Do they have retirement savings? Only because qualified plans sponsored by employers gets preferential tax treatment on condition that they cover lower income employees and that they provide proportionate benefits or contributions to lower income employees. The non-discrimination rules effectively require that in order to provide this benefit, and it's a very substantial tax benefit of roughly $200 billion a year of deferred tax of tax relief. In order to qualify for that, and of course, the high income employees and the employer value that potential for tax savings, right? The message is you have to include workers who would not save on their own, right? And are not in a position to take a reduction in their pay in order to put it into an IRA or some other long-term retirement savings program. So the non-discrimination rules are critical in order to get what? Adequate supplementation of Social Security benefits for the low and middle income segment of the workforce. Without it, those people wouldn't save, and tax deferral wouldn't cause them to save, because about 40% of US households pay no federal income tax. If you look at the bottom 40% of the income distribution, right, they're not paying income tax, and the tax advantage in qualified plans is tax deferral. Well, tax deferral doesn't give you anything if you got no taxes to defer, right? So it's for that reason that these non-discrimination requirements are central in order to encourage retirement savings and the accumulation of adequate retirement income by a huge segment of the workforce. Now, that said, what's happened in recent years is more and more employers seem to be expanding the coverage of retirement savings programs that are not qualified pension, profit sharing, or stock bonus plans, that are not 401k plans. They are what are commonly referred to as top hat plans. And if you have a program that is a top hat pension plan, it turns out that it is not subject to the non-discrimination rules. It can be provided to a select group, and indeed, the definition requires that it be focused upon deferred compensation for a select group of management or highly compensated employees. If you have such a plan, it can be focused only on that group, and no non-discrimination rules apply. Nothing has to be set aside for middle or low income workers, on top of which none of the federal labor law protections of the Employee Retirement Income Security Act apply, right? So the vesting, funding rules, the fiduciary obligations that are imposed by ERISA on all other employee benefit plans, all qualified retirement plans, are not applicable to these top hat savings programs for this elite group of workers. And on top of that, no data is effectively reported in terms of the terms of the plans or the coverage of the programs. They can't obtain qualified, because they're not qualified plans, they don't get favorable tax treatment and a tax advantage. But on the other hand, right, they're not subject to the qualified plan rules, and therefore what? Not subject to the non-discrimination rules, either coverage or the amount of benefits provided. But they do today, at least since 2018, they do get substantial tax advantages. And the reason they get substantial tax advantages is because Congress in 2017 lowered the corporate tax rate so far below the tax rate applicable to many individuals, many middle and higher income individuals. And the result of that lower tax rate is that even though these are not qualified plans, right, there is an implicit substantial tax advantage of saving through these top hat pension plans, okay? Because the income accumulates at a lesser tax rate than if the employee were to take the income directly. Now, the result of all that is that, right, these top hat pension plans, right, are taxable on distribution if they're properly designed. But even though they're not qualified plans, the amount that is going to be distributed, because they're accumulating at this low 21% rate, is fairly substantial, right? And the consequence is, right, that use of these top hat plans focuses additional retirement savings on the group of employees who can afford to save on their own, who want to save on their own, who have substantial tax exposure, and for whom tax deferral is very advantageous, and you can limit it to that group under these top hat plans. And it turns out that data seems to indicate that in recent years, more and more employers are, instead of expanding the coverage or the benefits provided under their qualified plans, are adding on top hat plans that are no longer simply focused on the highest paid executives, the people in the C-suite. They're now being offered to a broader swath of high income, high skilled employees, technical professional employees, managers, right? And they're being provided additional retirement savings, which they want, right? But they're being provided through these top hat plans, which means that they can be provided additional retirement savings without providing what? Proportionate benefits to lower and middle income employees. And so the consequence of this is that we have now many consultants, executive compensation consultants, basically selling these top hat plans. This was a graph that was data that was presented to the Labor Department a few years ago, where the focus of this presentation was top hat plans are essential in order to provide adequate retirement savings for these high paid middle management, technical and professional employees who are earning roughly $150,000 to $350,000 a year, right? In order for them to accumulate enough to maintain their standard of living, they need not just Social Security benefits, right? Not just the 401k plan, the qualified plan benefits, but they need on top of that more. Well, why do they need more? They need more because the assumptions behind this graph is that what? The 401k plan is funded exclusively by the employees, the plan members deferring a part of their salary, with the employer putting in no extra money. Now, employers are allowed to put in employer contributions and very substantial employer contributions. And if the employers did that, this 401k plan, there would be no savings gap here, right? And you could adequately replace the income that's desired by those high paid workers, those high value technical employees could be provided exclusively through the 401k plan if, in addition to the employee's elective salary deferrals, the employer put in more money. But that's not happening anymore. And it seems to be that the trend is becoming that employers are finding it more cost effective to satisfy the demand for additional retirement savings by having a 401k plan financed only by employees voluntarily putting aside a portion of what would otherwise be their take-home pay, employee elective deferrals, the employer not putting any matching or additional contributions of its own in, but then topping it off with one of these top hat plans that is not available to anybody but this very highly paid segment of the workforce, which is what is commonly come to be known as mirror 401k plans, right? Which are designed to satisfy the demand for high paid workers for adequate level of retirement income, but to satisfy it not through a qualified plan, which means that the employer to that extent does not have to provide comparable contributions or benefits on behalf of the lower paid segment of the workforce. I think we're done.
Don't leave the thing. I'm going to ask each of them one question. So I have a good question for Peter. So I'm reading the newspaper. It may have been online. I can't remember. And I hear about this Japanese guy who signs a contract in California, Shohei Ohtani. So this is what they reported. I want Peter to comment on whether it's true. He believes it's true. And if so, is it bad? And explain the tax aspects. So Ohtani signed a 10-year contract for $700 million, in which, according to what I read, $680 million will be paid after he leaves the United States and returns to Japan. So what is the tax planning that's going on? And Does he save any money? I mean, my memory is Japanese tax rates are higher than our tax rate. So Peter, what do you think?
I'm I'm inclined to take the international aspects of this and send them back to you.
Yeah.
But it looks to me like, I mean, from what little international tax I used to do years ago, right? It's still U.S. source income, right? It is still
It
U.S.
is.
source compensation income. And it's subject to U.S. tax whenever it's paid, even if it's not paid currently, right? So what's going on? I think this is just another specialized, non-qualified deferred compensation program, right? Which means that it doesn't get the tax deferral inherent in a qualified deferred compensation program, right? But assuming the employer is a corporation, right? It's going to accumulate at that 21% tax rate rather than his 37% tax rate for 10 years or more, right? So the tax advantage, again, is the rate reduction that's inherent in the fact that the corporate tax rate today, since 2018, is so much lower than the top rates of tax on individual income. I think that that's the tax aspect of it. I think there may well be issues with respect to the salary cap in Major League Baseball. I don't know that side.
Right. All right, now I'm going to ask Connor a question. So I'm not a real of a wealth tax. So should I be rooting that the Supreme Court agrees with the Moores?
Well, first of all, I just want to say on the baseball one, that was the question that I thought had the beginnings of a good exam question in it. So take note. One thing about wealth taxation and more that I think is quite interesting on a number of levels is Justice Kavanaugh asked Solicitor General Elizabeth Prelogar at oral argument, would your answers be different if we were talking about an individual wealth tax? And she said, yes, I think that would be a direct tax subject to the apportionment requirement. So in the oral argument, the Solicitor General conceded that there would be a different constitutional analysis that would apply there. And my suspicion is that some number of justices will find a way in whatever they write in the Moore case to note that the wealth tax issue is off the table. That's my suspicion. I would be very surprised if the petitioners prevailed in Moore. So even though the the quadrillion-dollar consequences are fun to think about, I think it's extremely unlikely that those consequences will come to pass. And the reason for that, I think, is just another kind of Kavanaugh and to some extent Justice Barrett happening in oral argument, where once in a while listening to these arguments, Justice Kavanaugh quite helpfully will say, here's what I think about the case. And at the more oral argument, he said, quite helpfully, here's what I think about the case. There was realization, and the only question is attribution. Can Congress attribute the corporate income to the Moores? And he thought the answer to that was yes. And I think for the Moores to prevail in this case, probably they're going to need at least two of the three of Kavanaugh, Barrett, and Roberts, and I just didn't see that at the oral argument.
Okay, now for Sarah. So Sarah, I have like 60 elderly Scottish cousins. Elderly means they're my age. They've never earned a lot of money, but they've saved up a lot of money. And so when it's income tax time in Britain, I'm not kidding you, my cousins have like shoe boxes and they go to Inland Revenue and they hand the Inland Revenue agent their shoebox. And, it's got wages and things they spent money on. A lot of it is stuff that's not deductible in anything. You can contrast it with our system where each individual is supposed to figure out his taxes. And I think our system is so complicated that I think the British system works better. So what do you think?
Don't know a lot about the British system, but I'll agree this one is complicated. So a lot of countries actually generate the tax return for you, right? And then you just sort of object. We are tasking our people with actually creating it. And because the IRS has no funds, they actually don't go after non-filers anymore. So that increases the tax gap. But there is a wonderful thing in this country called VITA, which is the Volunteer Income Tax Assistance, which is actually something the government funds, where lower income people at least, or people that don't have their own businesses, can go and get their tax return prepared for free. So I'm all for that. But in general, we see people make mistakes. You go to H&R Block for a simple W-2 return and they charge you $350. So we have some problems. So maybe England's better.
Yeah, okay. Now I thought maybe other people would have questions. So anyone want to ask a question? Yeah.
I think it's entirely. Well, first of all, I mean, four votes for cert, not five. So I think it's possible that there's some complicated math there. I think this really genuinely could be a case where the justices made a mistake, where some number of, I do think it's unlikely the petitioners win, even though on average, more petitioners win Supreme Court cases than respondents. I do think it's unlikely the petitioners win. And I think the only explanation, or the kind of set of explanations that I would go to for explaining the cert grant, is something like the justices thought it would be an easier issue than it was. I don't know. I suspect Peter probably has a view on that too.
Well, I just maybe note that the Chief Justice was apparently involved in the cottage savings case when he was at the Justice
They
Department.
did the argument.
Yeah, and was not happy with the court's treatment back in whatever that was, 1990. So I think he may have been interested in revisiting the issue, and I don't know where the other 3 votes for cert came from.
I was just wondering, hopefully, as the I think I'm like,
Go ahead.
sorry, guys. Hopefully, as the IRS increases its technology and gets better with that, if we do arrive at a technological ability to generate those tax returns for people, or at least for folks who have rather simple tax returns, what does that do to the tax code? And does Congress need to then pass like a whole new giant tax adjustment? Or is that something the agency itself can sort of put into place?
I think it's something that the agency can put in place itself. They've had the ability to use scanning technology for a decade or more, and they've just chosen not to. But yeah, by 2025, they are supposed to be able to scan every document before it leaves the mailroom. And because they're so paper centric, in addition to the 76 million tax returns, they get 125 million of pieces of paper correspondence every year. So that would be some really good basic technology that would make a huge difference.
David.
2 questions. One about the IRS. Do people within the IRS believe that there's a lot of money to be recovered from high income people? Because a lot of that will be tax avoidance rather than tax evasion. And they'll have to fight like hell, a whole bunch of tax lawyers, in order to recover. So the return may not be great. That's one question. The other one is about the wealth gap. My impression was that a large number of corporations were in fact matching 401 contributions. Is the trend changing and corporations are dropping the matching contribution feature that has been, of course, in the law from the beginning?
So I'll answer quickly. For every dollar of audit for high income individuals, so the estimate is $400,000 or more, they believe they'll get about $14 back. But yeah, tax attorneys are amazing, so who knows?
And on the wealth issue and retirement savings in particular, you're absolutely right. Many, indeed most large corporations do have either matching employer contributions or employer contributions that are independent of the amount of elective deferrals made by the employee under a 401k plan. But there does seem to be a trend, and the problem here is that the data is weak. It's mostly based upon industry surveys, but there does seem to be a trend to reducing and certainly not expanding the amount of employer money going into 401k plans, limiting or cutting back on employer matching or employer contributions, leaving more and more of it to employee elective salary deferrals supplemented by these top hat plans.
Yeah, we have an online question from our Zoom crowd. What is the political impetus for reducing the tax rate for the wealthiest of our population? Anyone like to take a lead? Great question.
Say that again. What is?
You bet, what is the political impetus for reducing the tax rate for the wealthiest of our population?
Well, so the traditional argument, which was tested, now Peter will wring my neck for saying this, was tested when Ronald Reagan was president, was you push the tax rates down, and if you do it significantly, more people will not be motivated to cheat or will report more fully, and your revenue will go up. So in the 1986 Tax Act, we did just that, and our revenues went up. Now, the problem is, how do you control for what else is going on in the economy at the time? We were in an expansionary phase in the economy by the time the thing happened. So it's a matter that tax people disagree about. Peter, do you want to say?
Yeah, I guess I'd say that the traditional argument is, in particular, that high marginal rates deter work effort, right? And they deter risk-taking. And therefore, that was the Reagan argument, we need to be very cautious about the top rates in terms of economic productivity. Fine, but a top rate was 40% for a very long period in the 1990s in the Clinton administration, and again during the Obama administration, and we seem to have had reasonable economic performance then. So reducing beyond what we have now, I think we don't have good data.
Panel, we have one last question.
Okay.
Hi, all. Sarah, you mentioned that the IRS doesn't go after non-filers anymore, so can I just not file?
Oh, but Zane, you should file because now they have money and they're going to spend it on training and they're going to go after you. So bad plan.